All right. Hello, everybody. Welcome to the last session for the IDRA online conference for today. We have one more day tomorrow. Um, if you don't know about IDRA, I'm sure many or all of you do, but it's the Indigent Defense Research Association. Um, you can learn more about us at indigentdefenseresearch.org. You can join our listserv there. You can check out our newly launched research database, and you can donate to us if you would like. I think that's all I have to say, and I think I'll pass it over to Shelby to get this session started.
Awesome, thank you. I'm just gonna share my screen. Can everyone see good? Perfect. Okay. Hi, my name is Shelby Sirivore, and I'm a contractor working with the Deason Center. Today, I'm going to be talking about overcoming barriers to public defense, a change theory approach to adopting PDOs in Texas. So our research question is, why do some Texas counties decide not to create PDOs despite research suggesting their benefits and the existence of state-initiated funding programs? So first, I'm going to give some background on public defense in Texas. Texas uses a decentralized system where each county creates its own system for providing public defense to defendants. In 2001, the Fair Defense Act passed, which required counties to adopt formal procedures for providing defense. This created the Texas Indigent Defense Commission, or TIDC, which is the state agency in charge of funding, overseeing, and improving public defense in Texas. So there are four main options for public defense. The first is to create an individual PDO, which is operated in-house, typically more expensive because the county carries the cost burden individually, and it's locally operated and controlled. There are also regional PDOs, which join with nearby counties and operate out of one county in the region, which is typically the most populated one. This is typically cheaper because the burden is shared by multiple counties and also means that resources and decision-making are shared amongst those counties as well. There's also a contracted public defender office, which contracts with a nonprofit to provide the actual public defenders, which is also often cheaper than an in-house office because the county isn't responsible for overhead costs like office space. These nonprofits typically serve multiple counties at a time and can also work within a TIDC funding structure, which I'll talk about in a minute. And last is the appointment wheel, which is when private attorneys take appointments in addition to their retained cases. Similarly to option 3, the county isn't paying for operating costs, making this cheaper than an in-house option, typically. And the court will rotate through these attorneys on an appointment wheel. They're paid out individually. And this is kind of what I'm going to be referring to as a status quo system, or what most counties kind of started with when they're looking to adopt a PDO. There are other options like Max and other things, but all of the interviews that we're going to talk about kind of fell into these categories. So I'm just going to leave it here. So TIDC provides a variety of funding and improvement mechanisms, but the two main ones relevant to this paper are the regional funding for rural counties and improvement grants. For rural counties, TIDC will fund 2/3 of an office if the rural county forms a regional office with nearby counties. So this leaves 1/3 of the cost of an office to be split between the counties and a regional office. There's also improvement grants, which are designed to assist counties that want to open a PDO individually. And they typically require the county to match TIDC's contribution. So with all that, our project focuses on interviews. So we interviewed local stakeholders in Texas counties throughout 2020 and 2021 to better understand the processes for decision-making around the creation of PDOs, or the decision not to create PDOs. So we interviewed individuals in 4 different groups, including judges, JPs, commissioners, and providers, to ensure that a range of topics would be covered, including budget, the provision of services, and any decision-making processes. Overall, we interviewed 46 people in 23 different counties, some that had implemented a PDO and others that had not. For those that worked in counties with offices, we asked questions about what the system was like before the office was created, how the implementation process began, and their personal opinions of the office after the implementation was complete. We did have to contend with COVID, so these interviews were conducted over Zoom. And then after the interview process completed, a team of 3 students coded the interviews using in vivo. Each student coded 2/3 of the interviews to ensure that there were at least 2 versions of the coding. And I was actually one of those students, so that's how I got into this project. So this is a table showing the distribution of the interviewees across roles, broken down by those that exist within a county that has an office and those that don't have offices. So in the next few slides, I'm going to be walking you through a change theory framework that explains the steps to successful adoption of a PDO in Texas according to the data in our interviews. For each step in this framework, we compared the data from interviewees in the PDO counties to those in counties that did not have a PDO to analyze potential roadblocks in this adoption process. So here's the framework. It starts with establishing financial viability, which is almost a prerequisite for the adoption of a PDO. Most interviewees mentioned the cost or budget constraints as the #1 qualifier or disqualifier for opening an office. Next is the identification of problems or needs. So without feeling that there's a problem with the current system, counties are less likely to adopt a PDO. Third is a triggering event or catalyst. This is often an individual pushing for an office, such as a judge or local attorney. It can also be attending a conference or being contacted by a state agency to discuss grant options. Once the triggering event occurs, the county must be able to reach some kind of consensus amongst its decision-making bodies for the change to actually occur. This often means judges, commissioners, and the local bar kind of coming together. And lastly, the government must actually operate to create the change, which begins the implementation process. This paper isn't going to discuss the actual implementation process or the sustainability of the systems, but those are 2 really important pieces to evaluating office success. So maybe in the future, we'll dive into those. So first, establishing financial viability. As I mentioned, this is kind of a prerequisite to office adoption. I wanted to caveat that this is perceived viability, as we don't know the actual financial state of the county. This is just based off of comments from interviewees about how they perceive the cost of the PDO and how they perceive their own county finances. So with that, in counties with public defender offices, interviewees mentioned that adopting the office would be cheaper, oftentimes due to grants from TIDC. They also mentioned that having systems that they have systems that are already large enough or expensive enough that the PDO would be the same cost or less for them given their caseloads. So in these counties, this viability is established and the implementation is more likely to occur given alignment with the other remaining steps in the framework. In counties without public defender offices, interviewees mentioned that an office would be more expensive than their current system, even with the grant funding. They also mentioned that they were too small or that they didn't have a large enough caseload to justify an office. Some people also mentioned that the district attorney's office and the PDO would have to be equally funded, which wouldn't be possible if a PDO was implemented. So because this perceived viability wasn't established, it's unlikely that the county will implement a PDO, even if they align with other steps in the framework. So I did pull some quotes to highlight kind of this viability. I'm not going to read all of them, but I'll just kind of read these bolded points. One person said, because if it could be proved that it's cheaper not to have the public defender's office, we wouldn't have it. I can tell you that, kind of highlighting how important this financial piece is to this decision. Another person said that they'd be perfect for a public defender's office because they're already paying enough money to support one. In the group that didn't have a public defender office, someone said it sounds like it would be too expensive because they weren't spending the same amount of money that we were spending. So they all said no. This is reflecting that the person in this county wanted to start a regional office with surrounding counties, but because those surrounding counties felt that it was too expensive, they all said no. And by association, this person then can't create one because they would have to create the regional one to be able to proceed. And then this next person said, we're small, we can't afford one. I think it's the financial end of it. That's the only thing that's holding it back. Again, implying this importance of financial viability. The next part here is identification of problems and needs. In counties that implemented a PDO, the most common problem was a lack of attorneys, which meant that the county wasn't able to keep up with rising caseloads and that local attorneys were burnt out and unable to provide the same quality of defense. In counties without a PDO, interviewees often mentioned that they had enough attorneys or that their current system was working well and they didn't see a reason to change it. So overall, if there isn't a perceived problem or need, it's unlikely that a PDO is going to be adopted. Here are some quotes that show this distinction. People in the PDO county said, lack of defense attorneys, plain and simple, our caseloads continue to grow and our number of qualified attorneys has not. And those that didn't have them, one quote said, we have enough attorneys here that are willing to take appointments, and so I don't see the need for a public defender. Okay, third step here is the presence of a triggering event. So these are kind of three triggering events that were mentioned the most. One was the presence of like a local champion that pushed for the opening of an office. Another was attending a conference or summit where PDOs were pitched. And another was being approached by TIDC with some sort of grant proposal. So in counties that didn't have a PDO, interviewees mentioned that they didn't know anything about them or that they'd never been approached by someone proposing one. So this is kind of a lack of event that could contribute to the decision not to adopt by omission. Some interviewees in this non-PDO category did mention that they were discussing opening an office, but had ultimately decided against it due to the lack of financial viability or the lack of need, kind of implying the importance of the first two steps in this framework as these like prerequisites. Again, some quotes. So counties with PDO, one person said that they were at a summit and they started talking about the public defender offices and the fact that they have grants and bells and whistles were going off. So they went and relayed that information to the county judge and got right on it. Another person said that they had never considered a public defender's office and had never been approached with a proposal, kind of highlighting this lack of a triggering event. The next step is consensus. So this is consensus amongst local decision makers, such as judges in the commissioner's court. This is a complex step in this list, as the differences between the two groups is less distinct than in the previous three steps. Many of the same concerns exist for both groups, such as concerns about the local bar or the cost. The only real difference is that the group with the PDOs decided to find some way to reach consensus and overcome, and the other group just did not. So in counties that decided to open a PDO, there kind of was a range of discussions about building consensus. Some interviewees mentioned that they decided to join a regional office because opening an individual office would have been too expensive for them, kind of highlighting that they were willing to take steps to kind of overcome these financial barriers. Others mentioned that they were concerned for the local bar, but felt that if the local bar needed jobs, they could always join the PDO. Again, overcoming this potential barrier. In counties that didn't open a PDO, interviewees mentioned pushback from the local bar or not wanting to join a regional PDO because of like giving up some control over how they run their system, and also not wanting to incorporate public defenders into the courtroom because they would slow down case processing. So these obstacles were ultimately just too big for them to reach consensus and acted as the final barrier to PDO adoption in this long list of things. So here's some quotes in the counties with PDO section. We have someone saying that the real political risk that they faced is the local bar. Is the local bar going to be mad? And they didn't have that problem. Said that I had counties with no lawyers, so there's no one to be mad there. Another person said, having the commissioner's court buy into this program was a little bit sketchy at first, but I've not had a problem since. I just tell them what number we need to put in the budget, and that it is something that we have to do. Kind of showing that they were just able to overcome any issues or concerns at first. In the counties that did not have public defender offices, one person said, I will tell you that 100% of our bar is on board with what we have in place right now. None of them are interested in running a public defender's office or wanting to limit their practice to that. I mean, if they became a public defender, then they're going to have to take first and second degree felonies, and they don't want those cases. Another person said, people are going to burn me at the stake for saying this, but the people that get DWIs, you actually put on probation instead of dismissing the cases. I get a lot of money from this, but that's the truth. And then you start generating money. And then once you do that, you can start talking about adding a public defender's office. But the public defender, what are they going to do? They're going to try to assert the person's rights, and all those cases are just going to get stuck. Kind of showing this frustration with incorporating new variables into their processes. And last, we have government operating to make the change. This is the step when decision makers come together and get commissioners court approval, judge approval, create local agreements or grant agreements, create an oversight board, and ultimately create the office. So in counties with PDO, this is a long quote basically showing how all these things came together. So the person pitched the plan. It happened really fast. They had a frantic back and forth with creating the office and funding it, and then creating the commissioner or the oversight board, and then plugging people in there, and then hiring the chief, and all these things, just showing how it really took a lot of things to pull together to actually create the office. And then counties without a PDO, obviously, there was no government action due to a lack of consensus. So with that, that's all the steps in the change theory that we developed. This paper is still in the drafting stages, so I'm really looking forward to any questions or feedback that anyone has. Thank you.
Oh, Josh, if you have a question, please preempt me.
No, go ahead. I can wait.
Okay. Thank you for that presentation. I wanted to ask if there's is the idea behind this change model to kind of like make this easier, or is this primarily something that like we just want to describe the process? Like, do you know if do you guys have any plans to like implement this as kind of like a here's what we need to actually do in these counties to make these PDOs happen, or was that kind of outside the scope?
I think eventually getting to that point is probably a good thing. At this point, it started with just describing and trying to identify these like roadblocks. And then eventually, I think obviously suggesting ways to remove those roadblocks to make adoption easier. I will say TIDC is constantly doing new improvements on their programs and allocating more funding and doing all of that. And so I think that's probably going to end up being a big piece of adoption, is just the funding piece. But yeah, I think that's kind of next steps in the drafting, is figuring out how we want to apply and what we want to say going forward.
Go ahead, Josh.
Or thanks. Thank you, Shelby. This was really fascinating to listen to. I guess I'm wondering a couple of things. You just, I don't know, respond to whichever one you want, or whichever one is, I guess, most interesting to you. One thing I'm curious about is if any of the interviewees may have said like contradictory things throughout, basically, throughout the different questions or throughout the interview. If someone maybe said that, we don't necessarily have, for instance, like our caseload is not big enough, we don't need it, and like pay parity with prosecution would be an issue, because there seems to be like maybe a tension in holding both of those at the same time. And one of the other things I'm curious about is if your interviews ever touched on maybe how consensus might have been built over time, like after the establishment of a PDO, even not maybe with the decision makers who have to, decide to establish this, but maybe with judges who initially were opposed, but later on realized like, oh, this is, maybe a good thing. Cases are being handled in whatever way that made it seem better. And I guess the very last thing is I was a part of an effort locally to establish a misdemeanor public defender office. I was sort of on the periphery of that, but the local bar was quite upset initially. They spoke at the county commission hearing, were very opposed, and having like a local champion and then a sort of organizing effort to bring out other people to speak really was what pushed it over the edge. So we also experienced the same thing here in Kansas.
Awesome. Yeah, thank you. I'll try and go in order. So there was some conflicting statements within interviews. It's mainly people, I think I did the caveat about the perceived, because I think a lot of times they say like, oh, we don't need attorneys, we have attorneys, but then they'll also say things like our attorneys are overworked and they're traveling, 4 hours across counties to go do these things. And so it's like, okay, well, those seem conflicting to me, but to them didn't compute that way. And so there is some of that going on. As far as the what was your second question? I just draw a blank.
The consensus building over time.
Consensus building, yes. So that definitely happened. That was actually a huge theme that I didn't really go into in this presentation, but was more opinions of the office and whether they think that the office will continue and is like the sustainability piece. And that was talked about by a lot of people, especially judges who felt that case processing had improved. It was nice to see the same faces in court every day. Public defenders would do things that maybe the private attorneys hadn't been doing, like going to the jail and trying to get people counsel in jail, or being in court just on random arraignment days in case someone got appointed, they could just meet with them right then. So just going like an extra step in a way that they had the ability to, because they had an office there, they had resources and whatnot. So I do think that I can't think of a specific instance of this, but there's definitely times where people had mentioned, oh, so-and-so didn't want us here, or that, this person didn't want us there. And that opinion would change over time, just seeing how the office worked. It also worked the opposite way, where some people really loved the office, some people thought it went really well. But then there would be instances of, oh, the sheriff hates us and doesn't want us there, so we can't enter the jail. Or, oh, the DA hates us because we outfund them now, or, we get more funding and they get less, and so they don't like us. And so there is still some of that conflict happening throughout. Yeah, and it's really cool to hear that you had similar experiences. That is validating. So
yeah, thank you.
Can I ask a follow-up about the consensus building? Because that was the moment, Shelby, where I thought in your model, Shelby, at times you said we, which was awfully generous of you. This is all your work. There were times in the consensus section of your model, what I noticed was you actually struggled to distinguish the PDO from the non-PDO counties because they both had some level of dissensus. I wonder if, just speaking from experience, it might not be a matter of building consensus, but only a powerful majority, because it's unlikely, really, that a public defender office will ever be created with absolutely no opposition and it will all be sort of resolved. You only, I think, would need to reach the point where enough people who had a stake in it and could help you make a decision were on the same side. Is it possible that that's what that should be called rather than consensus? And would that help distinguish the groups?
I think so. And even going further than that, it's honestly like the main decision-making bodies are the commissioner's court and the county judge. And there's this weird interaction going on in a lot of these counties where the commissioner's court handles things like the budget on like infrastructure. And the minute that there's any sort of legal question, they just pass it off to the county judge because they're like, that is your area of expertise, that's what you know. And so it's really about convincing the county judge to then convince the commissioner's court, which is kind of the same thing. And so I don't even know if it's a majority as much as that interaction that's important. So, I think there's more to be looked into with that too, because, obviously there is some conflict happening with local bar and other things too. But I think personally, that's why I think that the financial piece is so important, is because you're trying to convince that decision-making body who are in charge of the budget.
There's also a question in the chat from Mike Johnson about expert witness funding. Is there allocation of expert witness funding on the PDO side or non-PDO side? I'm not sure if that's like specific to the financial portion or.
I'm not sure about expert witness funding. Was that specific to like if TIDC also funds that, or just if the counties are allocating that separately from PDOs?
In the area of forensics, scientific testimony,
You're not coming through, Mike.
Oh,
We can hear something, but it's not coming through. You might just be typing it now.
can you hear me now?
It's a little better.
Okay. This is in relation to scientific testimony, such as in forensics, and other areas in the forensic discipline relating to the case, especially to the defense in opposition to the prosecution.
Yeah, that's a good question. I am not sure about that. The financial side of this is a little bit black boxy, but that's certainly something I can dig into more. If you have other questions, I can look into that.
Okay. Thank you.
One thing that might be behind Mike's question is that, assigned counsel lawyers often have to go direct to judges to ask for expert witness funding, and public defenders on the other hand can sometimes provide that in-house more easily. I don't think we know if that's a transition that happens in Texas, but it is among the really interesting points about contrasting these different systems. But certainly also, at least in Texas, there's nothing. I wouldn't necessarily assume, actually, that because public defender offices themselves vary so much, that would be something that would come with public defender office adoption, or that it would be part of the conversation in creating them. I mean, I guess you would know, Shelby, because you read the interviews, if this ever came up.
Yeah, I know that it came up with things like investigators and social workers, that some offices have those people on staff as like internal resources, and people had mentioned that that was a benefit of having public defender office, is that the private attorneys don't necessarily have access to the same resources that way, and if they do want those things, they have to go hire them individually. So I'm not sure if expert witness is included in that necessarily, but that's the only thing I can think of that would kind of link that transition.
I have a question for you, Shelby, and this might be unfair because I was a little bit familiar with the project, but actually just don't remember this. You contrast counties that create public defender offices with counties that don't. But my recollection is that one important piece of the design here, and you may have mentioned it, I might have just missed it, was the counties were themselves matched. And so the counties that didn't create public defender offices were in a sense intended to be similar to the ones that did. And the idea was that we would somehow be able to get a sense of why a county that's on the cusp would go one way or the other. Can you say a little bit more about that design, if I've got it right?
Yeah, I don't know if I knew about the matching as well as you did. I was a student when this happened, so this also been a long time in the making, but it makes sense that that is what we did because they're also very similar. But yeah, I don't know if you know more about the matching process.
Yeah, my recollection is that we tried to get counties sort of similar size and stuff like that, and maybe sometimes geographically adjacent, although I can't remember if we did that or not. And also, what happened that we didn't expect to happen was in the counties that had no public defender office, and this was validating, we would often find that they had talked about creating one and they decided not to. It wasn't simply that these were counties where no such discussion had ever happened. And so that was sort of validating that we were getting these counties that were just right on the edge of a decision. And so it gives you this opportunity to compare why they go one way or another, which I think is worth emphasizing in the context of your analysis, which is precisely about why people go one way or another. So we should recover those notes at some point.
Yes, we'll do. No, that makes sense too, especially because a lot of these counties, like I think I said 23 different counties we ended up covering. I'm not sure now what Texas is at with the number of public defender offices, but there's a really good spread of regional versus individual versus contract too, and just balancing between the different even types of systems that exist. So.
I know, Shelby, in regards to the expert witness situation, back in 2008, during the budget crunch, federal and all the states, we had to make motions before the judge to force the issue of getting approved a expert witness on a particular case. And that was really cumbersome because we had to do it so much back then because there was no funds. And it was just, you know, pretty bad situation. So I just wanted to clarify that. I didn't know if the situation now is the problem in allocating the funds for the expert witnesses.
Gotcha, thank you. Yeah, I feel like I can do another read through. Honestly, there might be a code we have about expert witnesses that I'm just what didn't make it in here, but that is a fascinating issue as well.
All right, I think we can move on to the second presentation, and we can continue with any questions at the end, if that works for you guys.
All set, Shelby, any closing thoughts for you?
Nope, you have the floor. Thank you.
Yes, thank you, Torin. Thank you, Shelby. Thank you to everybody for persisting through the end of the day. I don't want to keep you any longer than needed. I think we're scheduled all the way through to 5 Eastern, and we'll see. We'll see how we go.
Technically 4:50, but you could
4:50. All right. Yeah. I don't want to. Again, thank you for everybody for persisting. Here's what I want to share with everyone. In fact, well, speaking too soon, it seems, because I'm just struggling with my screens and everything else. I'm going to share with you today this presentation, a synthetic control of the analysis of the impact of public defender office creation in Texas. So my presentation goes with Shelby's a little bit. This is why we wanted so much to present together. My presentation is about the question of, after you create a public defender office, what is the impact of it, particularly on appointment rates? Is it possible that after a public defender office is created, one of the consequences might be that actually the rate at which people are appointed counsel goes up? And I'll say a little bit more about why we think that might be, and also why that would be such a sort of interesting and also problematic sort of a policy issue. But the reason I wanted to do this with Shelby was Shelby is talking about the fact that in some Texas counties are getting, people are getting together and they're deciding to create public defender offices. That I think is part of a larger national trend. It's certainly part of a trend in Texas where the state is trying to sponsor that development. And so as these offices are created, and in fact, as offices are created across the country and everywhere, we need to be thinking all the time about what the implications are of this change in system type, right? And basically from usually some pre-existing system where judges are picking attorneys to one where there's a staffed office of some kind to actually do the work. And that's not to elide or obscure the fact that these offices all vary really, really widely. But that's what this is about. And because Texas has been a place where, as Shelby discussed, there's been quite a lot of this kind of activity recently. And also because the Texas Indigent Defense Commission has such a long archive of data about how many people are actually getting lawyers in all of the 254 counties that there are in the state, we can trace and look at the impact of those offices. We can even get data from before they existed and see what kind of a difference they made. So without further ado, I'll tell you a little bit about what synthetic control analysis is and everything else. But as I say, I don't want to, I'm liable to ramble, and I will try to keep it tight-ish. Well, I'd be able to make it a bit tighter if I knew how to advance my slides, so please bear with me. Here we go. All right. This is our question. There are these public defender offices around rural Texas. And as I say, circumstantial evidence already suggests that they might actually be increasing the rate at which people are accessing counsel. So what's appointed counsel. What's going on there? Previously on the Deason Center, this is our little recap of prior IDRA presentations that you will have seen on this channel. Shelby and I published this paper. If you cannot afford an attorney, none will be appointed for you, with our colleague, Dr. Victoria Smigaki, who unfortunately can't be here today because she's preparing to pass the bar. In this paper, what we were doing was looking at misdemeanor cases around Texas. We were particularly interested in misdemeanor cases because, at least in Texas, there's a stronger right to counsel in felony cases. There's a much more stronger implication that you ought to have a public defender or some sort of appointed attorney in felony cases. But in misdemeanor cases, it's almost completely at the judge's discretion or a matter of local policy. And for that reason, actually studying Texas counties and the rate at which they appoint people counseling misdemeanor cases is just really empirically interesting, because there are some places where it's really common and other places where it's non-existent. So focus on misdemeanor cases because you think it'll allow us to take the sort of temperature of local policy making in this. We're looking across Texas counties. Of course, this is, as I said, a state where a lot of public defender office creation has happened, and we do have this focus on rural areas, and that's because actually most urban Texas locations do have public defender offices, not all of them. But the innovation here seems to be to create public defender offices in rural areas, something which rural areas themselves don't always think to do. There's always been a discussion in public defender offices, it's still in the ABA 10 principles as revised in 2023, that public defender offices is expected to occur in places where the caseload support it. And so they're associated with high volume jurisdictions. What Texas is doing is specifically trying to put public defender offices into rural places. And so what's happening is, I think partly because of the state intervention and the funding streams that Shelby was referring to, is creation of public defender offices where they might not otherwise exist. And as such, it's a really interesting experiment. These are, I urge you not to read this whole table, but I will highlight this one line. So in that paper that I was just talking about, there's this massive table in it at some point, and lurking in there is this one line. Now, what this is telling you is this is a cross section of Texas in 2019, and we took all 254 counties, and we looked at the rate of appointment of counsel in those counties, and we just looked at whether the county in 2019 had a public defender office. And what we saw was that the appointed counsel rate, which is to say, if all defendants have appointed counsel, it's 100%. If none of them do, it's 0%. The appointed counsel rate was fully 19 percentage points higher in counties with public defender offices. The retained counsel rate was no different. You can see it says 6.58758, but there's no stars there, so it's not a significant finding. No difference in the rate of retained counsel. And then the rate at which people are proceeding pro se is lower by almost 19 points as well. So the possible story here is that, you know, places with public defender offices are actually providing, well, the correlation is that places with public defender offices are providing more misdemeanor defendants with counsel. But that's as far as it goes, right? It's certainly a very provocative sort of a finding. If you look at these are two maps of Texas that do show the creation of public defender offices. I'll replace these with better maps one day, but TIDC helpfully has produced these two, so you can just look across 2020 to 2024. Anything that's colorful on these maps now has a public defender office. You can really see the rapidity of the growth of these offices across the state. Between those 2 years, and in fact it started shortly before this. The policy principle, of course, is that counsel should be appointed immediately after arrest, detention, or upon request. This is the ABA principles. Importantly, the ABA principles make no distinction between public defender offices and assigned counsel programs. They don't say that in public defender offices, in public defender office jurisdictions, it's more likely that access to counsel will be higher. Of course, there's no such distinction. The policy principle is that it should not matter what kind of indigent defense provision you have, how likely the defendant is to actually get a lawyer. But based on that correlation we saw in Texas, it does seem to matter. It actually does seem to make a difference what kind of jurisdiction you're in and whether you have a public defender office. What is the probability that you will get an appointed lawyer? But it's just the correlation, right? We don't necessarily know. So that means that empirically there are two possibilities. On the one hand, it could be that when a jurisdiction creates a public defender office, it causes the rate of appointed representation to go up. You can't tell that from the correlation, but it is one possibility that would be consistent with the correlation, is that sometimes jurisdictions, as they have in Texas recently, create public defender offices. And when they do that, the rate of appointment of counsel suddenly bumps. Or it could be something else, of course. It could just be that the correlation is just the correlation. So the other possibility is that public defender offices are produced in places that already tend to have high rates of representation, right? In other words, we've got to the point of correlation. We have the question, is correlation causation or not? And that's so important as a policy matter, because if correlation is causation in this case, if it is the case that Texas counties appear to be producing more representation by counsel just by making public defender offices, then I would certainly argue making public defender offices is good public policy, at least in Texas, or at least based on the historical data that we have. Or it could simply be that what really is happening here is that all those colorful counties on the map are places where people care a lot about giving people counsel, and even if there was no public defender office, they would have this high rate of representation anyway. So how can you tell the difference? Well, the key here is that Texas has been publishing data on the rate at which people are appointed by counsel in its counties for the last 20 years. And so and in the last 20 years, a lot of those counties have created public defender offices. And what that means is we can look back before public defender offices existed and see how many people were getting represented at those times in those years, and then cut the data at the point where the public defender office was created and say, does it change? And so and I'm going to show you a couple of examples of what happens when we do that. So at first, I'm going to show you the most compelling example of this really, really being what's going on. This is Duval County, Texas. This is the rate of representation by counsel, by appointed counsel among misdemeanor defendants in Duval County, Texas, going all the way back to the year 2006. And Duval became part of a regional public defender office in 2016. What happened, and you can see that before 2016, the rate at which misdemeanor defendants were being appointed counsel in this county was less than 10%. It was actually bouncing around zero. Nobody was getting a lawyer in misdemeanor court in Duval County before the creation of this office. And the office is created, and the increase in the rate at which people are actually getting counsel in this court skyrockets, almost to the point that everybody has it by the end of the data in 2022. It's a really striking example. So, and this, at least preliminarily, seems to give a much more clear indication that we're not just talking about correlation. We might be, in the case of this county, talking about causation, that creating this public defender office has a really seismic impact on the changing the rate at which people are actually appointed counsel. I'll get to whether it's statistically significant in a moment. That's when the synthetic control comes in. But as a visual, I think you'll agree, it's still very compelling. On the other hand, we have Burnett County. Burnett County is a much more ambiguous story on the face of it, right? Just look at what this graph looks like. Burnett County created public defender office in 2012. Before 2012, the rate at which people in misdemeanor court are getting appointed counsel is already going up. It finally hits kind of 40% in 2011. And then after the public defender office is created, is it higher or lower? It just seems to stabilize right around that time, I would say. And so is it clear that in this case, the public defender office, was associated with this large increase in the rate of representation by counsel? I don't think it's nearly as clear as you would say it is in Duval County, although you might like to say it's a bit of a shame that we can't go back before 2006, but here we are. This is how far back the TIDC data go. So how can we actually figure out which of these counties, and by the way, there are about 20 of them, which have created these offices, have had this effect and which of them haven't? This is where the synthetic control method comes in. So the synthetic control method is, it solves a problem that researchers have when you don't have a control group, right? We don't have a control group in the sense that if you're looking at Burnett County and you want to ask the question, what does Burnett County look like if it had no public defender office? That question is impossible to answer because there is no such thing as Burnett County that didn't have a public defender office. We only know Burnett County that did. And so what a researcher might do is find another county that looks a bit like Burnett, maybe one that's next door, something like that, and just compare between those two, and that will get you a little bit closer maybe to sort of saying, okay, you know, you can see that Burnett departs from the trend of the other county or something like that. But that's often not very satisfactory because the other county also won't be exactly like Burnett. What the synthetic control method does instead, and it exploits the fact that Texas has 254 counties, of which 172 are classed as rural, according to the USDA, is it looks across the 100, and Burnett's a rural one, it looks across the 172 other rural counties in the state, and it matches them on the basis of, principally on the basis of this part of the graph. Remember this, this part of the graph before 2011 in Burnett County that has this trend of rates of representation by council. That's the part of the graph that exists in Burnett County from when the Public Defender Office didn't exist. The synthetic control method will look across all of the 172 rural counties, or 171 because you can't look at Burnett again, and it will look for counties that have the same kind of trend. And it will also match them on the basis of things like, you know, well, anything else you want to tell the method. But I think we put a few other demographic factors in there and stuff like that, population, things like that. And instead of looking at just one county and saying that's a bit like Burnett, it actually creates what it calls a synthetic control, which is a composite of counties, which most closely matches Burnett County in the pre-public defender era, right? So that's the way it works. It takes 171 other counties. It looks at all possible comparison counties for the best pre-treatment match. Pre-treatment is before the period in which the county was treated. This is a medical metaphor, by introduction of Public Defender Office. And then the synthetic control is not one county. It is a weighted average of the other counties that best match Burnett. And so then, because those counties never created a Public Defender Office, you can look at the period after 2012 in those counties and say, well, where does their rate of representation go? What does that weighted average across those synthetic control of that synthetic control county actually look like in comparison to Burnett or in comparison to Duval? And so here's what happens when you do that. If you're in Duval County, you already saw this graph. If we make a synthetic control county that matches Duval as close as possible between 06 and 15, and then take all of those other counties that are in that synthetic control, look at their trend after 2016, and average those, what does that line look like? And here's what happens when you do that. So Duval County now is the black line. The synthetic control county is the blue line. And so this now verifies much more clearly that Duval County is indeed departing from the trend that you would have expected it to take had it been typical of other rural Texas counties and had it not created a Public Defender Office. So this then adds a yet clearer indication that Duval County indeed looks significantly different to the Public Defender Office was created. I apologize, I've got a noisy dog here. You probably can't hear it, but it might be the reason my sound is cutting out. I'll keep going. He's very excited. And then the final step is actually to determine, is this Public Defender Office county in Duval, is Duval County significantly different from that blue line? Is the difference between the black and the blue actually statistically? I got it. And the way that you do that is you run placebo analyses where you look at actually all of your other counties, you do matches, and you see how far they depart from that. And if you do that, so the question is the space between the black and blue a real space? Is it statistically significant or not? Now this picture is going to distort for a moment, but what I'm going to show you is that if you focus on the range of expected values within a 95% probability range that Duval could have fallen into is that blue cone. And instead what Duval did was its black line was most of the time outside the blue cone. And so that's how you know that with a 95% probability anyway, Duval County was the appointment rate of council in Duval County was statistically significantly higher after the creation of the Public Defender Office in comparison to before the Public Defender Office. And this synthetic control method is a statistical method that is usually used to support causal inference. And so what that implies is that in the case of Duval, creation of the Public Defender Office caused, unless there's some issue with the method, caused an increase in rates of appointed counsel in misdemeanor court cases. So that is really cool. Now, as you know, I picked the most striking example in the whole state to do this analysis. So let's have a look at instead Burnett County, which I deliberately picked as a much harder to tell kind of example. If we do the synthetic control in Burnett, you can see that Burnett is most of the time higher than where the synthetic control line is. It's not that much higher, and it isn't always actually higher. And so when we do the statistical significance testing, the question is, will that black line be outside the blue cone or inside it? And in fact, it's mostly inside it. And for that reason, in the case of Burnett, we say we cannot be sure at the 95% confidence interval, we can't be sure that there was a significant increase in the rates of appointed counsel in misdemeanor court in Burnett County. And so this one actually doesn't look like it made a big difference, for all that, you know, the rates are higher than where they were predicted to be. So last thing is to go through all of the counties in Texas that have done this. As you can see, they've opened at different years. So Willacy is, for example, opened one in 2009. One product of the method, because we're using all the years after the Public Defender Office was created, is if you created your office in 2020 as the bottom 4 did, Frio, Gillespie, Carnes, and Kerr, there is less data for us to actually do the significance test on, which does mean it is harder for us to find. It's just mechanically harder for us to find those to be statistically significant than a place like Willacy that opened in 2009. Nevertheless, what we see is, first of all, walk across here, you've got these are 7 counties that opened a standalone office just within the county. In every single county, you do see rates of appointment of counsel that are above the significant, that are above the synthetic control line. That's why every difference is registered as positive. Everyone ends up having more appointment of counsel than would have been expected in the synthetic control model. However, it's actually quite rare for them to reach the level of statistical significance that would allow you to say this is definitely a real difference. So in Willacy, we can be pretty confident of it. In Lavaca, we can at the 90% confidence and not 95. Nevertheless, you know, certainly it's sort of a consistent picture here, and you know, the data are noisy, very interesting. And then what's not shown here is that Texas also in this period, for the data that we have in rural counties, did produce 3 different regional offices as well. One was in B County, which at first served 3 counties and later on served 2 more. You can see a bit more evidence there of significant increases of these offices implicitly causing increases in rates of representation by counsel. Another was in Starr County. Starr is absolutely the star of this story. In Starr County, rates of representation by counsel in all 3 counties served in that hub significantly increased, implicitly caused by the creation of the office. And then the last one is the Far West Texas Public Defender Office. Far West Texas Public Defender Office, a much tougher picture over there, not evidence really of significant increases. It's the only place where you actually see some negative numbers in the 3rd column there. Culberson actually couldn't be tested. One of the tricky things about this situation is that all of these Far West Texas counties had almost no counsel being appointed before the Public Defender Office came in. And when there's a lot of zeros in the data, one thing that happens is I don't really understand this in a technical way, but the regression model itself ends up getting zeros in it, and then there's zeros, and then things get divided by 0, and that is impossible to do. And so actually the statistics break down if you have a lot of zeros. But so one slightly sobering thing is that Culberson was assigning very little counsel before 2018, and that meant we couldn't even analyze it using this particular technique. Anyway, still, I mean, to the extent that you have significant findings here, it's all significant increases implicitly caused by the creation of these offices. One thing that I have to unfortunately finish on a kind of a negative note here, because one of the things that has happened recently in Texas history, and Shelby knows more about this than I do, is that the Starr office was closed in July 2023 by a local decision. We are, I promise you, checking what's happening to rates of representation by appointed counsel in that misdemeanor, in those misdemeanor courts. So the conclusions are public defender offices do sometimes cause increases in representation of appointment of counsel. Local context matters. Counties do differ in degree and the existence of impact. I think, I mean, I started talking a little bit about Culberson there, but I think that, you know, we know a little bit about far west Texas. We know a little bit about these other jurisdictions. We can start to speculate about why offices succeed at this and why they don't. And we should caveat by saying this isn't the only measure of success, of course. This is just one interesting thing. And the last thing is to say that Texas context might matter. There are other states like Texas, but this is one of those places where you've got a certain amount of state oversight, a lot of local control, a lot of local decision makers. And I think it might matter that what's going on here is the state is sponsoring public defender office creation. There's funding there to take if you want to do it. And that's certainly not true everywhere. And the second thing is the state then very often, I mean, and Shelby talked about this in a qualitative piece, the state is doing things like approaching counties with cost estimates. It's holding conferences where it promotes the availability of funding and will do analyses for you and will help you set up the offices. I think that, and apart from just representing sponsorship, another thing that does therefore is create this local investment. It creates local interest in it. And it could be that when you create public defender offices that way, one thing that happens is everybody gets on board. The sheriff's excited, the judge is excited, and one consequence of all of that coalescence or coalition might be that rates of appointment in misdemeanor cases go up. Because this is not a policy that the public defender controls, it's really something that the judge controls. Although certainly indirectly there's lots of things they can do. So that's what I've got. I'm really interested to hear reactions, and I will stop now. Thank you.
I definitely have a question. And it's one that I've not used the synthetic control method. And it's possible I'm missing something in this question. It's just wrong-headed completely. But one thing that we do that has a similar goal, is we have in Indiana we have people that are inside our system and people that are outside our system, and we hope that being inside the system, which gets you funding but also makes you follow rules, has some kind of effect. And so we do a lot of comparisons on people inside versus or counties inside versus counties outside, and we also have some historical data, not as much as I would like, but that allows us to look at that over time, and we found some good effects, and I think those are encouraging, at least, is what I would say. But one thing I always worry about is something that I think came up in Shelby's presentation, and so I'd love to hear both of your response from this, which is I can't remember your exact wording, but like kind of the singular event that causes a change in, like, allows a PDO to appear. So like one that you said was a local champion, and that's like 80% of our cases are probably have a local champion to get inside of our system. And so my worry is that those local champions are causing the introduction of our system, but they're also causing a bunch of other things because they care a lot about the public defense system. And so in these cases of PDOs, might it be that like there's a judge that like really thinks we should make a lot of changes, and one of those changes is to open a PDO, and another one of those changes is that we need to get people appointment. And so there is a real causal event that's happening at the development of the PDO, but it's still not, it's kind of an A causes B and C versus a B causes C situation. Is this something that you've thought about? Am I missing something? And is that even plausible? Because my immediate response to myself is nobody is showing up and making sweeping changes all at the same time. Like, it probably takes them a year or more to get a PDO going. But anyway, I'd love to hear both of your thoughts on that.
You want to go ahead, Shelby?
I think you should go first.
Okay.
I need to formulate my thoughts.
Yeah. I think that's actually correct. Actually, funnily enough, I immediately was thinking about the fact that yes, there is at least one very salient example of a public defender office that was created by a judge who just sort of made it his project. And so the answer, and so the question implicitly is, okay, so what's the causal mechanism or the causal reasoning here? And I mean, you're exactly right. I guess I should be describing this a little bit more carefully, because in other words, I don't think that public defender offices work by magic, right? I don't think that in fact, I specifically don't think that if you create a public defender office, you will always get this effect. Not at all. I mean, the data don't even show that. But also, I do think that there are circumstances where public defender offices are created in situations that are actually impossible for them, and things actually do get worse after they're created. Just saying that from sort of personal experience. So in fact, what we should be trying to describe here is maybe a little bit more richly the sort of specific situation in Texas where perhaps people are encouraged to come together or something like that to create public defender offices. Certainly the creation of the office does seem to involve, at least in this sort of Texas scheme, which is not universal everywhere. Because I came across recently offices in places like North Carolina and Virginia that are really created by state fiat. Local governments are just told that they will have them, and they just sort of appear, and nobody was expecting them. And that's very different in Texas, where what has to happen is that the local decision makers have to get together, and the state is really trying to carefully foster and foment that. And not dissimilar to New York, which I'm sort of familiar with as well, although New York's in some ways a completely different case, other than this local control thing. So I think that the answer is yeah. The causal mechanism here is not that a public defender office is created and there's something intrinsic to that institution that magically creates more representation. The causal mechanism is instead that something like a series of events are put in motion which lead to the coalition building that Shelby described, and all of that as a package results in this increase in representation rates. If we were to really break it down, I do think there are probably a few different possibilities. One is that if you have a judge who's committed to the mission, then they will spontaneously start appointing more people. I will say, in addition, we have seen other mechanisms at work. And one of those is that the public defender office, after it's created, does develop some kind of mission of its own and some sort of esprit de corps and some sort of strategy. And we do see around Texas public defender offices then deputizing staff to do things like go into the jail and find out who was arrested last night, or go to court even if we don't have a client today to see if there's anybody who needs counsel, or try and intervene with how the court actually does assignments and try and make suggestions about changes to eligibility procedures or streamlining and stuff like that. And so I can also think of creative direct policy interventions by public defenders which were intended to create more representation, and in fact created more representation as far as I can tell. So yeah, what you're making me think, I take your comment really to be constructive and only to just press us to kind of describe, to not, I guess I never really wanted to describe creating public defender offices as just a sort of a thing that you can flip a switch on and then it will have all the desired effects. What I really probably want to describe, and the reason I'm so pleased that Shelby's studying it the way she is that it's a very particular thing that has to bring several forces into play at once. And anyway, I don't know if that's, I should hand over to you, Shelby, and Torrin, to make sure I'm responding in the right way.
No, I think that's great. And I just wanted to add that I do think, I'm really glad you guys paired these together, because I do think they're perfect insofar as it really highlights how useful kind of knowing what is going on the ground in a way that data can never tell you, that you kind of need that narrative for, can kind of do exactly what you just did, right? Where you said, well, I do have examples in in counties where we see it's kind of like it's going from like a judge out, but then we have these other examples where there's PDOs that seem to be we have a causal story for them at least. And so I think building a model of how these things happen from qualitative data is kind of essential to our causal understanding of this more quantitative causal analysis. So I think they go really well together. And yeah, Shelby, I'd love to hear anything if you have stuff to add.
Yeah, I think the only thing is what Andy had touched on. Like, we do have some of these stories of a judge really wanting to push an agenda, and it's not just about opening an office. It could be, we weren't doing appointments at all, and we need to, and we need to do it this specific way, and whatnot. But also, just even outside of the judges on the local champions is less to what you're saying and more of, if we were to create a public defender office, who would we put in that office? Do we want someone from the state? Do we want someone from a contract organization? Or do we want someone that's an attorney right now in our county that knows our politics and our culture? And so I think in the causality conversation, I would be less concerned there of like, okay, well, I'm going to appoint someone that has lived there their whole life and knows our small little county. Who might just be the local champion in the sense that they have the trust of the community and less that they're really pushing all these agendas. So I think there's like a lot of different little stories that can add up to that. But that was my only kind of added thought.
I think that's great. Josh, did you have a question?
Yeah, thank you. Really, really cool study, Andy. Thank you for sharing it with us today. And I want to reiterate that it is super cool before I start asking about like the next thing, or like what some next steps could be. I'm wondering about, so like you have this increase in rate of representation, and in those counties where it is significant, what differences in outcomes you might be able to see for those cases, or if you even have access to the data that would allow you to look at that. And the other thing I was thinking about is if the data that you have for the appointment rates, if that includes misdemeanors that I guess like travel through, for like a better way to say it, travel through a municipal court where maybe like a justice of the peace is handling the case, and how that sort of difference in process might impact appointment rates, or how the case is handled, or how individuals are even sort of advised of their rights in those instances.
Astonishingly, I think I actually have answers for those questions. So, thank you for that, Josh. You're absolutely right about the next steps. Texas does also have some other historical data sets that we can look at. One, and I'm interested in two in particular. I will say first that or maybe I'll say it last. There are two other data. There's a Texas Commission on Jail Standards also has data on Texas jails going back quite a long way, and they can show the number of people detained pre-trial on misdemeanor charges, which I think is really interesting. So we might be able to show if the public defender showing up and suddenly taking a lot of cases is also associated with changes in pre-trial misdemeanor detention, which would obviously be fascinating. And also the state court system itself does have monthly reports from courts on their caseloads and indeed on the cases they're disposing and how they're disposing of them. So we can look at things like changes in rates of dismissal by month over time, and even, I mean, and there's even some other indications of counsel in there, but the caveat I think is probably like, I mean, if you're going to look at an outcome of creating public defender offices, I think that the increase in the rate of appointment of counsel might be the most direct impact. The idea that it will then have impacts on these other things is very, very tempting, but I don't take for granted that those impacts will be direct. But we could effectively do the same kind of analysis on them. So I do want to go and look at that. I have to rely on the technical expertise of others to run this kind of analysis. I don't actually know how to do it, but I understand it. To the extent that I understand it, I understand it. Your other question was about the actual scope of cases included, and the answer is that in Texas, there are no municipal court cases in here. Texas has what it calls county level courts, which is just divided into two different kinds of courts. They handle what are called A and B misdemeanors. All of those cases have jail as a possibility, and so that's where counsel is provided. In the municipal courts, generally a relatively clean divide where actually they're handling stuff where no counsel is required, and so the public defenders just don't have that as part of their beat. So we have this nice, for empirical purposes, relatively clean sense of like counsel should be going in all of these cases, and then if it's not, then you have a really obvious question about why it's not there, and we don't have to deal with the possibility that traffic is mixed in or something. Your point about JPs is actually kind of interesting though, because Texas does mix it up right there, because Texas has an initial appearance procedure called a magistration, which very often is in front of a JP. That is to say, not necessarily a lawyer judge in a very, very local court that only has jurisdiction over the case for the period of that initial appearance before they will hand it off to the county level court, which is the only court that can ultimately dispose it. And actually, for what it's worth, the county level courts also often don't have lawyer judges in them, but the JPs do have this responsibility of doing the magistration, which is the first time that the question about whether they want to be represented by counsel must be asked. So actually, these tiny local courts are the place where that question is first asked. Those tiny local courts do actually report out on how many defendants ask for counsel, and we do also have data on that. So we might be able to. That's not whether they got represented; it's whether they asked for it. So we might be able to look at whether the JP behavior, or their reported behavior anyway, also changes before and after. But yeah, I do think of it a little bit in terms of outputs and outcomes, in the sense that if you enhance your indigent defense system and then start using your indigent defense system, that might be the most predictable, most direct impact of it. Whether it would then change, case outcomes and pretrial detention, I think there's a good chance we would find some of that actually, and it might be in some way proportional even to the rate of representation. But I don't know. Data disappoint me so often in my presumptions about how the world works, and I'm ready to be disappointed again. I hope that got to everything that was on your mind.
It did, yeah. Thank you so much.
Any other questions or anything you guys want to say?
Well, I want to say on Shelby's behalf that she is new to the West Coast, and and the best indigent defense researcher that I've ever worked with. Also a former student, as she pointed out, and you all should hire her.
Thanks, Andy.
All right, that might be a good spot to close on, unless you guys have something else. Thank you all for sticking it out a long day, and we'll see you tomorrow at 12:20. So we start a little later tomorrow just because of scheduling reasons, but we'll see you all then. And thank you both to Andy and Shelby. This was, as you could tell already, I'm sure it's a very exciting pair of presentations to me. All right.
Thanks so much, folks.
Thanks.
Thank
See you
you.
again.